back to the official channel of Faculty of Law, Kurukshetra University. I am Divyansh, final year law student at Institute of Law, Kurukshetra University, and I am back with another video in which we will be discussing about memorial drafting and the written submissions which the participating teams are supposed to submit into the moot court competition. And for discussing this important part, today with us we have Ms. Kanupriya Saini and Mr. Shubham Rana.
Thank you, Divyansh.
Now, starting with my first question, I would like to ask Ms. Kanupriya, please tell what are written submissions or what, as we say, are memorials.
So, basically speaking, your written submission is a written form of your arguments. So, what are you going to plead in front of the honorable court is what you write in your written submissions. If I speak generally, so your arguments are the water, and your written submission is container for the same, Divyansh. So, your written submissions form the your primary impression in the minds of the judges because you have submitted written arguments primarily.
Okay.
Yes, Divyansh.
Following up with that question itself, should you please tell our viewers what is the need of these memorials or written submissions in a moot court competition?
Well, Divyansh, coming to the importance, so it's a general rule that an advocate cannot plead before the court beyond its written submission. Whatever he has submitted to the court, he has to argue on that point only, right? He cannot go beyond the written submission. Similarly, moot court is the imaginary courtroom of the actual courtroom. So similarly, things are happen here. We have to submit the written submission, and beyond that written submission, no counsel will be allowed to argue before this honorable court.
Okay.
That's why the written submissions are important. Second, that it's the reference for the judges, that what contentions, what issues the counsel is going to raise, what they are going to argue, what case laws they are citing, and all. Third, that it's for the opposite team, that they can note down their counterparts from this written submission on.
Okay.
That's why it's important for the moot court competition to prepare a written submissions.
Okay. And also please clarify to this point that the participating team, do they have to prepare their memorials from both the sides, like the plaintiff and the respondent itself?
Yes. It's the demand of the competition, of all the competitions, that they have to prepare the memorials from both the sides, because before draft lots you are not aware that whether you are going to plead from the petitioner side, whether you are going to plead from the respondent side. That's why it's important to prepare the memorial from both the sides.
Right, very clearly said. Kanupriya, would you please tell me now what are the constituent elements of a memorial or a written submission? What are the ingredients that goes into the formation of a written submission or a proper memorial?
First of all, great question, Divyansh, as this question is going to be the main focus of today's discussion.
Exactly.
So, the primary thing is your cover page.
Okay.
Next coming towards is your index, and then your list of authorities.
Right.
Then your statement of jurisdiction.
Statement of facts, and then issues raised, summary of arguments, that what are your arguments, just crisp, right? Then advanced arguments, and then followed by the prayer. That's the ending part, prayer.
Okay, so these are 8 to 9 basic ingredients which every memorial must consist.
Yeah.
Indeed, Divyansh.
Also, the parties have to prepare these things from both the sides. Right.
Yes.
Exactly.
Now, it would be very helpful for all the viewers if you elaborate all of these ingredients one by one, starting with the cover page itself.
I guess Kanupriya can betterly explain this.
Surely. Thank you, Shubham. Thank you, Divyansh. So, talking about the cover page, first of all, you mention the name of your competition.
Right.
For example, as we are going to organize in future our National Moot Court Competition, so that will be titled as National Moot Court Competition, Kurukshetra University, Kurukshetra.
Right.
So, you will be mentioning that if you are participating, National Moot Court Competition, that is Kurukshetra University, Kurukshetra.
Right.
And then you have to mention the nature of the suit.
Okay.
Okay. After that, the title of your case.
Okay.
Then jurisdiction. Jurisdiction is under which provision you have approached the honorable court. And I forgot to mention here that the name of the forum that you have approached is also you have to mention on your cover page, that is the Honorable Supreme Court or the Honorable High Court or the Competition Commission or any other forum that you have approached.
Next is the team code that the organizing team has provided you, the organizing institute has provided you. You have to mention the top corner of the cover page.
Right.
And the color.
Okay.
Color is most important. Generally the cover is the red or blue. Blue is for petitioner, red is for the respondent.
Okay.
But Generally it's the same, but it depends upon the competition to competition, what themes they
Right.
ask you to
Yes.
make.
Right. And next is the index. Please tell us about that.
Index is just like a can say the particulars or the contents of your. We see the book,
Yeah.
and there's the contents that what chapter is this, then
Yes.
followed by which chapter, followed by
Right.
which chapter. Similarly, the index.
Okay.
That one by one
Yes.
the list of
Yes.
activities which the memorial consists of.
For example, statement of jurisdiction is on your page number 4, so
Four.
you will be stating that statement of jurisdiction page number 4.
Okay, it is for the convenience of the judges,
Yeah.
so that they can
Convenience
refer
of-
to the same page which you want them to refer to.
Yes,
Sure.
yes.
Definitely, it is a
Yes,
very
yes,
helpful
yes.
thing that is to be included in written submissions. Next
Then
up, we
in
have the list of authorities.
List of authorities. List of authorities means the case laws,
Okay.
the web links, right? The statutes which you are using in
The
your
books.
memorial, the books. You have to mention all the list of these things in your memorial. Just
Right.
like a kind of index, we can say. Just kind of index, but not an index. You have to mention it on a separate page
Okay.
of the memorial.
Okay.
So that it may be convenient for the judges and for the opposing party that which case law you are dealing, how many cases you have put it up. Just in this way.
For the cases, you have to arrange the cases in the alphabetical order
Okay.
in your memorial.
Ah.
And talking about the web links and articles and other things, so try to rely on the things that are authenticated.
Okay.
For example, do not rely on the blogs because
Okay.
they are not the authenticated source that is being considered in the honorable code. Try to rely on the websites such as Supreme Court cases, Manu Batra, some
Live law.
reliable websites I'm talking about here,
Okay.
and the books that have that are admissible in the court of law.
Okay.
Do not quote anything that you are finding on internet.
Right.
Always
You
quote.
cannot quote the newspaper cuttings, newspaper headlines. Don't try to get such things in your memorial.
So means students shall prevent themselves from adding such things which cannot be authenticated or which might have a personal bias of the writer or the author of it.
Yes.
That is a very important
Yes.
point that students must definitely take into consideration. Shubham, please tell us about what is a statement of jurisdiction.
Statement of jurisdiction is that under which authority you are coming, under which authority you are filing your case.
Okay.
Right. For example, you are filing the writ petition.
Right.
Then you will come under the Article 32.
Yes.
Right. You are filing SLP. You are filing a criminal complaint.
Right.
That is known as the statement of jurisdiction.
Okay.
That why are you approaching this honorable court and what remedy you kind to seek from this honorable court. That is known as the statement of jurisdiction.
Right.
And you have to mention it in your memorial on the first page, that is the cover page,
Right.
and then you have to give the separate page inside your memorial, that is known as the statement of jurisdiction.
Right. And how do we code this statement of jurisdiction? Can you please tell us? Suppose a student is coming before Honorable Supreme Court under, say, Article 136, which talks about SLP. So how shall the student write that into that statement of jurisdiction?
So basically, you quote that you have approached the honorable court under this article, and
Right.
then make a footnote for the same.
Okay.
And in the footnote, you have to quote the bare language of the provision.
Right.
For example, you have approached the court under Article 136 of the Constitution. So you will be making the footnote for the same, and then you have to quote the bare language of the Article 136 of the Constitution.
Okay. That very clearly said, by Kanupriya. Now, moving forward, we have a statement of facts as well. What does the statement of facts consist of?
Talking about the statement of facts, basically, if you are preparing your memorial from the petitioner sides, so keep your facts brief. Do
Right.
not quote the facts. For example, the fact sheet states the facts of 2 sheets.
Right.
So do not quote the facts of 2 sheets. Try to make your facts crisp and try to state those facts which are going to support your arguments,
The facts which are in your favor.
which are in your favor. Rightly said, Shubham.
Right, very clearly said that the facts should not be completely copied from what has been written in a moot proposition.
Yeah.
Rather, it shall be made in such a form which is much more precise, crisp, and much more relevant to the case law or whatever the case it is before the court.
Precis writing to be followed when you are making the statement of facts.
Right, very clearly
Very
said that it is to be in the form that we are writing a precis of it. Right.
Yeah.
Moving forward, we have the summary of arguments. What does a summary of argument consist of, and how shall the students make it?
Yeah, well, regarding summary of arguments are the arguments can be of 2 pages, 3 pages. Just we talk about the statement of facts. Similarly, the summary of arguments.
Okay.
right? You have to make your arguments in just 4 to 5 lines,
Right.
along with your issue. That is your summary of arguments, right? For example, if I take the issue whether Article 21 is violative of something and something, right? So you are putting in that right to privacy, then right to livelihood, so and so contentions are there. You have to sum up all this and just make 2 or 4 lines about your argument. That is your summary of argument.
Right. So just like summary of facts we have, this is summary of arguments, and the detailed version of it is, I believe, is covered under the arguments
Argument
advanced.
advanced.
Please tell us about that as well.
Basically, arguments advance are what are you going to argue in front of the honorable court. You cannot go beyond your argument advanced,
Right.
first of all. So, while stating your arguments advanced, you have to first of all be clear. Be clear in your mind that what are you going to plead. Make a issue, sub issues for the same. For example, as Shubham has quoted an example of Article 21. So, for example, you are arguing on a case which involves right to livelihood or right to live with dignity.
Right.
So you are going to make sub issues for the same. So for example, your issue is whether a particular thing is violative of Article 21 or not. So your issue will be that, for example, it is violative. You are pleading that it is violated. So you will be make the issues that this particular thing is violative of Article 21. Then you will be making the sub issues that right to live with dignity is covered under Article 21. Then form your arguments accordingly. While forming the arguments, you have to keep in mind that first of all you have to state your argument, then back it up with the provisions. As I do personally in my memorials, I try to support it with one landmark judgment and one latest judgment.
Okay.
Support the every argument with a strong case law.
Okay.
Try to find out the latest judgment,
Right.
because sometimes what happens, we put the judgment of 1960, 1970, and it may be overruled in sometimes in 2010, 12, 18, right? So try to find out the latest judgment and support it with your argument. One more thing, you have to write every argument in a humble way, in a
Okay.
just way that it is humbly submitted before this honorable court,
Okay.
and it gives an excellent impression to the bench.
Right. What I understood from what they just said, first of all, arguments advanced have to be the submissions
Yeah.
which are going to be
Yes.
going before the court, which will include an elaborative expression of what the council is seeking in the form of remedy.
Yes.
Secondly, it must be well dissected. For
Yes.
example, if any article is being violated, then on what different fragments, on what different tangents that argument is being violated, it must be clearly and differentially stated into that argument. And thirdly, it must be backed up with some provision and case law.
Case laws.
And the case law must be landmark one,
Landmark.
either landmark or latest one,
Latest.
Latest.
keeping in mind that it has not been overruled by any
Yes.
another court.
Yes.
Well, that is a very important part which must be included in written submissions. And now I believe at the last of the memorial submissions comes the prayer. Please tell our viewers what is a prayer and what does it consist of.
So prayer means you have completed your memorial. You have cited your arguments and all. Now, ending part, what remedy you are going to seek, right? In a humble way, request from the court.
Okay.
What you want from the court to declare,
Right.
right, in your favor, right? And we generally there is a general criteria, but we write in this prayer. Wherefore, in the light of the justice arguments advanced and the authorities cited, may this honorable court be pleased and declared and hold that. Right?
So and so
Then-
remedy which you are seeking.
So and so, whatever you have raised in your arguments, what are your contentions, you have to write it down, and then you have to go down to the court, and in this way you end up your memorial.
The very basic and the general thing in your written submission, Divyansh, is that you have to stay humble throughout your written submission and throughout your arguments.
Okay.
Your humbleness is your key.
Okay.
In the moot court competition, your humbleness and your confidence is your key. Try to stay humble as much as you can.
Okay. Very clearly said by Kanupriya. Also, I believe these prayers, be prepared from the side of petitioners or the respondents, they would also differ in itself. That one party which is seeking the
Yes,
one remedy from the court, the other party would be seeking the absolute opposite. Of it.
Opposite of it,
Opposite
right?
of it.
Yes.
So that is very clearly said by
This is
Kanupriya.
because whatever you are contending, you will seek the same,
Okay.
right? If I am from petitioner, they are from respondent, other side. Obviously, there will be the oppositions,
Okay.
right? So they will seek accordingly.
Right. Very clearly said. Now coming to the next part, Kanupriya, you just said during these things that you were telling to us that any argument must be supported by a case law. Any precedent which has been set either by the Supreme Court or by the various high courts throughout the country. What is the proper method of citing a case law in your written submissions or while you are arguing into the court of law? What is the proper method of citing those case laws?
First of all, cite the case law with complete citations. That is the most important thing.
Right.
Complete citations means that you are referring to a particular reporter, a particular journal. For example, you are citing All India Reporter, you are citing Supreme Court cases, whether you are citing Supreme Court cases online or any offline journal you are
Right.
quoting. So, while citing in your written submissions, if you are stating the title in your arguments, so state the title in your arguments and then make the footnote for the same, and in the footnote state the complete citations. Or you are using the words of a judgment and you are not citing the complete title in your arguments, then make a footnote for the same and mention the title of the case with complete citations in the footnote.
Okay.
And complete citation means up to the page number
Up to
and
the-
including the volumes. Sometimes they're the volumes of AIR and the SEC. So you have to mention the page number. For example, the case is the citation of the case is AIR 1961.
Okay.
What the participants or what the teams do, that they just
Right. The
write
year of it.
Year
year
of-
of the case. But the what the proper method of citing the citation is AIR 1961 622 Supreme Court
Right.
Volume 2.
Okay.
In this
So
way.
the main purpose of complete citation is that you are quoting a judgment from an authenticated source,
Source.
and this is particularly being held by the honorable court.
Right.
So you are not making the castles in the air.
Right. Very rightly said. Now coming to the last part, which also relates to the case laws itself. Could you please tell our viewers what is a compendium and how to refer to the compendium when you want to cite a case law before the bench?
Right. Compendium is a bunch of judgments,
Okay.
compiled judgments,
Right.
right? You are arguing before the court. You need to support your argument with the case law, and whatever you are citing there, whatever you are pleading before the court, and you are citing your judgment, you have to submit it to the bench.
Okay.
Right? This is a two-way method. One is that you pass on the bench the loose
Loose
arguments. The loose judgments. Copy of the judgments one by one, one by one. Or the second way is making the compendium. Compile all the judgments you are citing in the courtroom in one kind of just
Booklet.
like a booklet. Yes,
Okay.
in a one booklet, and you have to pass on the complete compendium to the bench.
Right.
This is the need and the meaning of the compendium.
And you also highlight those points that you are using in your arguments. For example, you are citing the lines from paragraph number 4 of the judgment. So you
Judgment.
have to highlight those lines and use bookmarks for the same.
Okay.
If you are giving a loose compendium, not a compiled one, you have to highlight and bookmark that too.
Okay.
And if you are giving a compilation of your judgments, then you have to mention that this is number 1, this is number 2, and then while referring to that, you have to be like kindly refer to
Page number.
flag number
Flag
1,
number
flag
one,
number 2,
flag
flag number
number
3,
two.
and while referring to the loose judgment, you have to request the court to follow the flags for the same.
So that the court can directly approach to the part which you want them to seek, and they can get to the thing which you want them to be read as highlighted, which
Yes.
you've already
Yes.
mentioned through the
Yes,
booklets
yes, yes.
or the highlighter. So I
Yes.
believe it would so much convince the court in your favor that whatever you are citing, first of all, it is authenticated, and secondly, you are already providing the court convenience so as to reach to the same point which you want to establish into the court.
Because the courts are already overburdened,
Also-
and we are trying to just give the whole judgment and ask them to read out it whole.
They can't read it by
They-
themselves.
Also, Divansh, it shows your hard works and dedication towards the competition, that your hard work and competition towards
Yes,
this.
Definitely, definitely. I believe that marks the end of our this session, in which we covered about what goes into the memorial drafting, how the written submissions are to be formed, and the compendium, which forms a very important part of any moot court competition. I would like to thank Ms. Kanupriya Saini and Mr. Shubham Rana for giving their precious time. Thank you so much.
Divansh.
Apart from this, we will cover more important and vital parts in our next video. Stay tuned. Thank you so much. We'll see you in the next one.